Hello, everyone, and welcome to our webinar, Schrems II and the Validity of the Privacy Shield. I'm Lisa Hofmann, the Chief of Legal Operations here at Pridatect and Certified Data Protection Officer. I'm very happy to have Charles Meditrevet here with me today. He is our UK market specialist for GDPR and has a huge background industries and sectors with a wide range internationally in data protection. Welcome, Charlie. I'm so happy to have you here today.
Thank you, Lisa. Looking forward to it.
If you have any questions during the webinar, please fill them in the question part you have normally on the right side. Or afterwards, you can send us an email and we are happy to get back to you. But meanwhile, Charlie and I will try to answer all the questions we receive at the end of the webinar. So today we want to speak a bit about the decision of the Court of Justice of the European Union in the case Data Protection Commissioner versus Facebook Ireland Limited, Maximilian Schrems. It's called short because this is a bit long, the Schrems II case, and it was of 2 weeks ago. So that decision invalidates the European Commission's adequacy decision for the EU-US Privacy Shield framework, on which more than 5,000 US Atlantic trade US companies rely to conduct trade in compliance with EU data protection rules. And the Court of Justice upheld the use of standard contractual clauses. We will speak later also a bit about that, because this is also very important. Later on, we will also, because there are long terms, call them short SCCs. But it requires companies and regulators to conduct a case-by-case analysis to determine whether foreign protection concerning government access, for example, in the US, to the data which will be transferred meet the standards of the European Union. So for some countries, it's really not looking good, let's say that. And it will impact companies in the US and well beyond.
Okay, so in terms of content today, we have a little agenda here. As you can see, we'll be running through the basics of what the international data transfers are, the Schrems case and judgment that Lisa mentioned, as well as a deeper look at the now invalid privacy shield. Then on to some possible alternatives, such as the mentioned SCCs, and finally how we can make international data transfers post-Schrems II. I'll hand it over to Lisa now to get us started.
Yes, because to understand the situation a bit better, we should have a look at some key concepts, which Charlie and I will explain now. I will start with international data transfers under the GDPR. So the GDPR primarily applies to controllers and processors located in the European Union, European Economic Area, sorry, including a bit more, so short the EEA, with some exceptions. Individuals risk losing the protection of the GDPR when their personal data is being transferred outside of the EEA. And this is why the GDPR restricts transfers of personal data outside the EEA, unless the right of the individuals in respect of their personal data is protected adequately and in another way. So there are a limited number of ways which the GDPR provides for us, and we will later speak in more detail about them.
So the scope of GDPR obviously does not cover data transfers outside the Union now. This is where the Schrems II ruling comes in. The next natural question we have is, can they still be carried out? And the short answer is yes. There are mechanisms in place, such as the aforementioned SSCs, which we'll definitely dive into in a bit more depth a little later. First, Lisa is going to run you through the Schrems ruling and give you a bit of background on that in case you don't have a full understanding of it at the moment.
Absolutely, thank you, Charlie. So as we mentioned before, on July 16th in 2020, the Court of Justice of the EU affirmed the validity of standard contractual clauses and invalidated the privacy shield. So this case is actually a companion of the court's 2015 ruling in Maximilian Schrems versus Data Protection Commissioners. This is short called Schrems I. So yes, Maximilian Schrems is a data protection activist and lawyer fighting for data protection rights. So, and in this case, in Schrems I, the court invalidated the Commission's adequacy decision underlying the EU safe harbor arrangement. So the safe harbor before the privacy shield guaranteed the protection of data transferred from the EU to the United States. Then the privacy shield was basically the successor of the safe harbor, but the privacy shield also was a bit of a copy paste of the safe harbor. This is why the privacy shield decision is invalidated also, and with immediate effect from 2 weeks ago. And yeah, standard contractual clauses in this case, in this decision, are valid, but their use is subject to certain preconditions and ongoing obligations, which we will talk later a bit more in depth. And now, yes, I hand over to Charlie again with explaining a bit more the privacy shield.
Okay, so I guess it's probably more appropriate now to say the privacy shield was, as opposed to is, an adequacy decision by the EU Commission. And as we've mentioned, it guaranteed the safe transfer of data to certified US companies. The aim was to ensure, obviously, that the Union citizens' data was secure when moving it. Fairly common practice when you consider how often data is processed by a third party in the States. Finally, the foundation of the adequacy decision was that the international transfers could be made only when they comply fully with GDPR guarantees. Next, we're going to look at why the privacy shield is no longer valid.
Yeah, what I find most fascinating is that the privacy shield didn't even exist when this case was started. It was primarily about the SECs. And in this decision, Facebook kind of threw the privacy shield under the bus here. So the privacy shield was always left out by Facebook and the DPC. The whole time it was always only about the SECs. And yeah, they said like it's not applying the privacy shield. But in the final statement then, in the closing statement, Facebook actually said, but the privacy shield says that the US law is fine, so this needs to be accurate for the SECs as well. And this is general a valid statement, what they said there. But this left the counterparty no option to say that the privacy shield is not valid either, it's wrong. And yeah, this in fact, for starters, got the privacy shield in. And so the CJEU, the court stated that the limitations on protection of personal data arising from the domestic law of the United States on access and use by US public authorities are not circumscribed in a way that satisfies actually requirements that are essential equivalent to those under the EU law. This is what the court said. And what we have here is basically two laws colliding. So if the US doesn't change it's called the FISA 702. It's the law which includes access to data under certain circumstances. And if the US doesn't change this law, or if the EU doesn't change the fundamental rights, which they definitely won't, there will never be a valid agreement. So here we have really to see how we move forward here. We have a lot of privacy experts who already predict, like, I don't know, a privacy shield 2.0 or a privacy haber. But yeah, again, unless something really changes, it will be difficult to find a valid agreement, or let's say rather impossible. So now I hand over to Charlie.
Yeah, I definitely think it's at a crossroads there. So now we're getting to the exciting stuff, the standard contract clauses. So as mentioned, they're an alternative used in place of the privacy shield, sometimes alongside it, though perhaps a costly one in terms of time. They involve a separate contract that would have to be signed by both parties before the data is transferred for the processing, which would fulfill the security guarantees requirement. But it's important to note that any EU organization engaging in this form of contract may have to implement additional safeguards over and above the SCCs, though it's unclear from the judgment what the CJEU meant by this. As an ongoing discussion is being had, companies have to keep up to date to ensure compliance. This is an ongoing lots of moving pieces at the moment. And next, we're going to see how this could potentially be achieved. So continuing the discussion, all transfers made between the EU and US now have to be fully assessed for legitimacy. As we can see on the slides here, if the appropriate security cannot be implemented, which may be the case while organizations figure out alternatives to the adequacy basis, then the transfer of data should be suspended immediately. This means due diligence and analysis should be conducted before making any stateside data transfers, and not just for the main data processor, but for all customers and also suppliers, distributors, etc. On reflection, this appears to be the midpoint in this judgment, and it appears that the law and regulation is playing catch up a little bit, I would say. So finally, I'll hand off to Lisa for the last few slides here.
Perfect. Thank you so much. So yeah, let's talk a bit about Pridatect and how we can help with complying also in those difficult and uncertain situations here. Let's speak a bit about data protection in general, because it's always about detecting and identifying risks. So this you have to do in any case, not only in a court decision like this one. You have to figure out the risks. This is step one. Step two would be, of course, define and suggest measures in order to mitigate this risk. This is where Pridatect also comes into play, in order to define some measures you have to take in order, of course, to lower the risk and be less vulnerable. And then, of course, there's also, as we always say, as I say every webinar, to answer every client, that data protection is basically not a one-time thing. You have to definitely always monitor the implementation of those steps you have to take, and you have to monitor new decisions like this. We were speaking with some of our clients after this case happened, and say now we have to evaluate, of course, the transfer of the data, and they were not, of course, they haven't heard of this decision because they focus on a complete different spectrum with their company, and of course they cannot keep up to date with all these legislations. This is where we come into play. We come here, we sit down together and see what we can do after such a decision, what you need to handle. But again, you also always need to implement and monitor your data protection and see where the laws are changing. So with our technology, our data platform, data protection platform, you can do so many things. You can conduct the risk assessment, also an impact assessment. If you have like new technology in place, if you use a new provider, then you should maybe carry out an impact assessment. And we have privacy reports now. If an authority comes, requests something, what did you do? In the case of the change of legislation, this can be all handled with the platform. So you can also, of course, always try Pridatect. We have a 7-day free trial period, and also you can always speak to our great customer service. We have a free demo also, of course, to use. So just contact us and we can help you in this matter. So now we come to the questions. In this case, we of course received some questions. We also received them actually before this webinar, just because yes, it's so urgent. It's very interesting for everybody. So let's start with the first one. And it is, we already use SCCs for international data transfers. If we do not rely on the Privacy Shield, do we need to do anything? My answer would be yes, you definitely need to do. When you're the controller, you need to do like a case-by-case analysis, which we talked already about, and check if there are any national laws which this provider is subject to, what maybe violate the GDPR, or the Charter of Fundamental Rights, which comes also into play here. Okay, then next question. What are the consequences when do I not take action? So basically, yes, this is the question, are fines likely? I don't know what you say, Charlie. In my opinion, yes, because the CJEU highlighted that there is, it's the duty, this was Max Schrems also highlighted, that it is a DPA's duty to check, to act under this new legislation. So there is also no grace period, basically. They can fine from now on. But I would say, again, the penalties we all know are very high under the GDPR. So if we're talking here really about 20 million or 4% of the global turnover, which is a lot. And this applies, of course, when you transfer the data without a legal instrument. But it's likely that the DPA, so the Data Protection Authority, will not fine a controller if you can at least demonstrate that all the measures to comply with the ruling were taken as quickly as possible, I would say. No?
Yeah, I'd fully agree. I think it's as long as you went out of your way to do things in a timely manner, then you should be okay there. Yep.
Absolutely. Then next question, when are standard contracts viable? Can I still rely on them? You want to go ahead on this, Charlie?
Sure. They are, of course, still viable. It's a little up in the air at the moment in terms of the CJEU's commentary on them from Schrems. They said, you know, that further safeguards may need to be implemented without really specifying what those are. But it's definitely something you can rely on at the moment.
Oh yeah, absolutely. I would say too. But of course, you need to check what you are committing to in both cases, controller or processor. Because the SECs have normally strict obligations that need to be understood. And I think before, a lot of people were just like signing the SECs off and without maybe even reading them, then they were filed and they thought everything good, but without even like knowing the obligation. So you would have to check if there is anything in the law of the recipient that could create a conflict, as we mentioned before. And yes, if the conflict cannot be resolved, then the SECs would not be valid. So you could not rely on them. So yeah, this would need to be checked, of course.
Yeah, and just to highlight a point there, I do think there's probably going to be a bit more scrutiny for them after this ruling. They're going to be under a lot more scrutiny, so it won't be I don't think it'll be a case of signing and filing away. It'll be you'll really have to put the work in for that, I think.
Absolutely. Then another interesting question. Will it affect the adequacy of the United Kingdom after Brexit? What would you say here, Charlie?
I would say it's likely. Of course, we can't say for sure, depending on how the new DPA comes out in the UK. We'll have to see how that all pans out. It would be hard to give a concrete answer, but there will be ramifications for sure.
Yeah, for the companies, 100%, but normally the judgment should not change anything in the adequacy decision itself by the European Commission, because the criteria for adequacy they remain the same. They were defined before, in fact. So the court just has to evaluate what the law says about adequacy. So for the ruling, it should not have like any implications. But for the companies afterwards, definitely.
Yeah.
So then we have a question about like advice for Amazon Web Service. Yes, this is tricky. So for special solutions you have implemented in your company, we would love to talk with you. after the webinar, because this also, of course, depends a lot on the company situation. What would be the next steps here? What would be to do here? So we will be happy to talk with you about this after the webinar. We have a lot of questions about this, about Amazon Web Service and other providers, of course, from the US. Then I would say we close with a final question again, so, which would be, I mean, we kind of answered this throughout the webinar, but maybe it would be interesting to sum it up again. What are the next steps to do for my organization? So yes, if you rely on the EU-US Privacy Shield to transfer data from the EU to the US, you must immediately find an alternative mechanism here, because this is definitely 100% invalid. But again, SCCs are valid, so this would be another solution. But as a controller there, you would also have to kind of perform like a mini adequacy decision, like this case-to-case analysis, where you have to review the data flows and identify like the third countries where you transfer personal data to under SCCs, and then assess whether this third country provides an adequate level of protection of the data you're actually transferring here. And there you should take into account, you have the law article 45 of the GDPR, where you have like a lot of considerations, which you then should also take into account, of course. And you need to consider whether supplementary measures can be adopted if SCCs are not capable of ensuring an adequate level of protection here. And of course, again, document the assessment and the decisions you make, because again, if you can demonstrate that you took the right steps, you will be less likely in order to get a fine. Yes, that's this to this question. To our last question, what I have to say is that, yeah, it's still so recent, so new, that there will be a lot of developments during the next weeks expected, and then we will definitely know more about that. So yeah, thank you, Charlie, for joining this webinar today, and thank you everybody for watching.
Thank you, everyone.